Good morning, everyone, and welcome to today's webinar. My name is Danny, and I'm with the learning team at Cherry Bekaert. Just want to go over a few housekeeping items before we get started. For audio during today's webinar, you may listen through the phone or the computer speakers. You can choose your audio under the Audio tab in the menu to the right of your screen. To earn CPE for today's webinar, please make sure you answer all the polling questions. Make sure you click the Submit button to submit your answer. Instructors will try to remind you of this as each poll appears. The instructors and I will answer questions in the question and answer pod. We will try to answer them throughout the webinar. So that's all for the housekeeping announcements, and I will turn things over to Mark.
All right, good morning, everybody. Appreciate you joining us this morning. I am Mark Cooter. I am Cherry Bekaert's firm leader for the real estate and construction practice. Welcome to the third part of our four-part webinar series that's happening this week. Today, we are talking about distressed real estate post-COVID-19. Tomorrow will be our last and fourth webinar, which will be on year-end planning for real estate and construction companies. Because you're joining live this morning, you are eligible for continuing education for anyone that needs it. We will also be posting this webinar to our internet site at cbh.com if you'd like to join later or rewatch any part of the series. Also on cbh.com is past real estate or industry specific webinars that the firm has hosted before. So welcome, and with that, I'm going to turn it over to Rick Schneider.
Well, thank you, Mark, and welcome everybody. Glad you're able to join us this morning. Let me get my slides working here. There we go. So today, I'm a tax partner in our Cherry Bekaert's office up in Washington, D.C. And joining me today also is Jody Bedenbaugh and Sean Faulkner of Nelson Mullins, and they will be, I'll let them introduce their topics as we get to them, but we're glad that you're able to join, and we look hopefully that you'll get a lot out of this presentation today. And again, if you have questions, go ahead and submit them in the question box. So let me go ahead and get started in terms of what we're going to talk about. So the first topic is really going to be dealing with debt restructurings and workouts, and I'm really looking to address how through those processes you have potential tax impact. But before we get to that, we thought we'd start off with your first polling question. So go ahead and please submit your answer on the polling question, and then we'll move forward with the first topic. Don't forget to click your submit button. So it looks like we've got a few folks who've had previous experience dealing with debt restructurings or bankruptcy filings. Sorry for that, for those that had to experience it, but I mean, then we have some folks that don't have that level of experience. So we'll go ahead and move on with our first discussion then. So in dealing with debt restructurings, again, one of the things that we want to make sure is that tax problems can arise, particularly when through the restructuring process, oftentimes you're going to wind up with cancellation of debt income. And usually that occurs without necessarily a loss that'll offset that income. So examples of when that occurs is obviously when a lender writes down the loan, or there's a other significant modification of the debt terms. It can also occur when in the situation where the borrower is providing equity to the lender, or maybe a hope note in exchange for all or part of the debt. Again, that can result in cancellation of debt income. And then if you wind up in the situation where you're turning over the property back to the lender in a foreclosure or deed in lieu process, Again, in certain cases, that can also result in cancellation of debt income in addition to other income from the transfer of the property. And then in the fortunate situations where a borrower may be in a position or may have an affiliate that has the ability to buy back the debt at a discount, again, that can result in cancellation of debt income. So let's talk about each of these over the next few minutes. So in regard to a modification of the loan, the key thing is if you have a significant modification of the debt, what's deemed to occur for tax purposes is you have an exchange of the old debt for new debt. And when the new debt has a lower face amount than the old debt, then you're going to wind up with cancellation of debt income. So the key matter is when do you have significant modifications? When do you have to test that? When does that occur? So here's some examples of things that result in significant modifications. Again, any change in the principal, interest, or fees to the holder that results in a change in their yield on the note of at least the greater of 25 basis points or 5% of their annual yield on the old debt will be a significant modification. If you wind up with an extension of the maturity of the debt beyond the lesser of 5 years or 50% of the old debt term, again, that results in a significant modification. If you have a temporary stay of collection or waiver of default rights that is greater than 2 years, that will result in a significant modification. And I've noted here that you can have up to 2 years of a stay, and that can also include an extension of that period during a good faith negotiation or bankruptcy process. So that safe harbor, again, only applies to the collection, stay, or the waiver on default rights. Other examples of significant modifications includes a change of the obligor if you've got recourse debt. Or in the case of non-recourse debt, if you have a change in the security or credit enhancement that's on the obligation, such as a guarantee or changes in collateral. But again, if it's a recourse debt, those will not be a significant modification. So the nature of the debt obviously has a difference as well in terms of whether you have a significant modification in that case. Also, a change in the priority of the debt. If the debt winds up being changed in terms of its seniority or subordination to other debt, again, that results in a change in payment expectations on it. That can result in a significant modification. One of the areas that does not usually result in significant modifications is covenants. So any change in typical financial covenants within a loan agreement will not be a significant modification. So again, those are the examples that will result in it. And again, when you have that significant modification occurring, then you need to test to see if the face amount of the new debt, which also could include the adjusted issue price of that debt if the interest rate on it is below an applicable federal rate. But you compare that face amount of the new debt to the face amount of the old debt, and to the extent of the difference, you're going to have COD income. So let's talk about debt for equity exchanges. I mentioned that, again, where you're in a situation providing equity to the lender as a part of exchanging for their extinguishment of their debt, whether it's part or all of the debt. Again, whether it's stock in a corporation or a capital or profits interest in a partnership, when the corporation or partnership transfers that equity to the lender, if the amount of the debt is greater than the fair market value of that stock or interest, that's going to result in COD income. And so there's a safe harbor rule in regard to partnerships in terms of what's fair market value, where the IRS has allowed for the liquidation value of the partnership interest to constitute the fair market value of that interest. So that gives it a little bit easier ability to test in terms of what the fair market value is. But again, the fair market value of that equity compared to the face amount of the debt, the difference results in cancellation of debt income. So let's go through just a quick little example here with regard to a partnership. Again, in this case, we've got a partnership that has an asset that has declined in value to $500. The partnership is giving that equity, an equity interest of that $500 to the lender in exchange for the lender note for $800. So in that context, again, the partnership PRS is going to have $300 of COD income. So the key thing again is just to make note of how these different transactions and modifications can again result in COD income to the debtor entity. So let's go to our second poll again, which is which of the following scenarios will not result in cancellation of indebtedness income. So we've got an extension of maturity, change in the yield, change in loan covenants, or modification of the debt where the lender is getting equity. So again, don't forget to hit your submit button. So it does appear that most everybody is getting the answer correct, which is again, change in loan covenants do not usually result in a cancellation of debt income. All right, so we'll move along here now to next. So you tried to negotiate with the lender, that didn't work, and now the lender's taking back the property, either from a foreclosure process or you're deeding it back to the lender. So what happens in that case? Well, what happens depends on whether the debt is recourse or non-recourse. So in the case of recourse debt, you could have COD income for the difference between the amount of the indebtedness and the fair market value of the property. That'll be cancellation of debt income. The difference then between fair market value of the property and then the tax base of the property is essentially a deemed sale, so you're going to have gain from the disposition of the property. However, if you're dealing with non-recourse debt, then it's viewed as if you sold the property to the lender for the amount of the debt. So there's no COD income resulting in that case. You're going to wind up all with gain from the disposition of the property. So those are, again, things to keep in mind is really what is the nature of the debt. You got to look at your debt instrument. You got to look through, is there any guarantees on that debt? You also have to look in terms of the entity that's, made, that is the debtor entity. Is it an LLC and none of the owners have provided any guarantees? Most likely then the note's going to, that's going to be treated as a non-recourse debt, absent any other provisions in the loan agreement itself. So it's critical to look at your facts and determine the nature of the debt for this purpose. All right, so occasionally I've seen in the situation where the borrower or an affiliate of the borrower may be in position to acquire the debt at a discount. If that occurs, it's going to wind up with cancellation of debt income to the borrower. So, and if the affiliate, again, if the affiliate's a related party, it will result also in cancellation of debt income to the borrower upon that acquisition of the debt. So typically in these cases, planning purposes will look to try and structure an entity that by bringing in a third party to create an entity that is not related or deemed related for tax purposes to the borrower if they're looking to try and acquire that debt. So again, you're having to go out and find a third party who's interested also to acquire this debt at a discount along with your affiliate. So that's just one thing that can occur. But again, if you don't have that situation, you got related party or the debtor's acquiring it, you're going to have COD income. So I've talked about COD income now, what's creating it. but is COD income always bad? Well, not necessarily. Again, there are exclusions provided in the tax rules for avoiding income from COD in the case of the debtor being in bankruptcy or if the debtor is insolvent. So if you're talking about a corporation, again, this applies in the corporate viewpoint, whether it's a C corporation or an S corporation, if that entity is in bankruptcy or insolvent, then the income from COD can be excluded. Now there's a cost to that exclusion, and I'll talk about that in a second. If, however, the entity is a partnership, for partnership purposes, you look through to the partner to determine if the partner is in bankruptcy or if the partner is insolvent. So the test is at the partner level. So that's unique for partnerships. And we'll go into that a little bit more in a second. The other way to have income excluded from COD is if the actual debt that's being discharged is qualified real property business indebtedness. And I'll define that in just a second. So let's move on. So in the case of insolvency or bankruptcy, again, whether you're talking about the C corporation or S corporation that's in bankruptcy or insolvent, or a partner in a partnership who is in bankruptcy or insolvent, they can exclude the COD income, but it's going to result with them having to then reduce tax attributes. And these are the different tax attributes they need to reduce in the order in which they need to reduce them. So if they have NOLs, they would reduce those first. Obviously, you'll see down below on number 5, you've got the basis of property. Again, that's pretty common and that we see going to the basis of property. But this is the order in which those reductions occur. So effectively, you're deferring essentially the income out into the future. So the key thing about this is that these attributes are reduced on the first day of the following year from when the discharge occurs of the debt. So that gives the ability to utilize these in the year of the discharge. And again, I make note in terms of if you wind up with losing the asset in the process of creating the COD, then obviously you can't reduce the basis. But that's the cost of the reduction in the case of bankruptcies or insolvency. Again, here's a quick overview of COD as it relates to, sort of a general set of rules. So again, if you're insolvent, it applies to any property that you would have. Any loans that are eligible can be viewed in the context of the discharge. So there's no particular limitations there. But again, as I mentioned, if the borrower entity is a partnership, you got to look to the partner to be insolvent. And then, of course, the partner then has to reduce their tax attributes. Same thing in a bankruptcy. There's no restrictions in terms of the property, no restrictions regarding any of the debt being discharged. But again, if the borrower is a partnership, you need to look to the partner, and that partner must be in bankruptcy to avail itself of the COD exclusion. And then, of course, have to reduce their tax attributes. With regard to, so if you're not insolvent, you don't have a bankruptcy, and again, this is probably oftentimes occurs in partnerships, but you've got a solvent partner, for example, they would look to how to avail themselves is really with regard to real property business indebtedness. You can exclude COD income for that, and that applies when you're dealing with trade or business real property. So it has to be property used in a trade or business. Rental real estate is an example of that. Real estate for a manufacturing company that they own as part of their manufacturing plant would qualify for that. The debt itself needs to be what's referred to as acquisition indebtedness, essentially debt used to acquire the property or debt used to construct the property or improve the property. And it also needs to be directly secured by the property. And that can also occur through a disregarded LLC entity. but that's the debt that will qualify for that purpose. So if you have that being discharged, then you can avoid COD income by reducing the basis of the property itself. Now, if you don't have sufficient basis in the property to the extent of the COD income, you can also elect to reduce the basis of other property. And again, this is unique for entities other than C Corps. The trade-off in terms of the with this basis reduction is that basis reduction is similar to like depreciation. You sell the property later on, you may have depreciation recapture. In this case, you're going to have recapture of that basis reduction as ordinary income when you later sell the property. So that's the general rules that apply in terms of being able to exclude the income from COD. So where do we wind up getting to? In terms of basic tax planning goals, as I mentioned, if you're a solvent taxpayer, you're going to be looking to try and realize maybe gain. Usually it's going to be capital gain from maybe the disposition, the transfer of the property back to the lender, as opposed to trying to have income. In the case of solvent or bankrupt taxpayers, they're more apt to want to have COD income because they can then exclude the income from taxation. If you're in a partnership, you have these types of partners, solvent, insolvent, or bankrupt partners, you can see where the motivations are going to be a little bit at a conflict with each other in terms of their goals, in terms of going through this process at the partnership level. So that's just one thing to keep in mind. So in the partnership as well, some ways to plan around COD income. If you know you're going to wind up going through a restructuring, you know you're going to have COD income as a result of it, how can you maybe avoid that COD income, make it a little bit more palatable? In the case here, it's you can do one of three things. One is to incorporate the partnership before you go through the debt restructuring. And if it's an insolvent partnership, you got to watch out. The IRS may challenge that incorporation event. But typically, if you wind up with an incorporated entity, obviously the COD income doesn't flow to the partners anymore. It's being dealt with at an insolvent corporation, then it's able to exclude the COD income. The other two is either abandonment of the partnership interest and or taking a worthless deduction for the partnership interest. In the case of the abandonment, if the partner still has a share of the liabilities, which is probably going to be the case, the loss on the abandonment will wind up being capital loss. In the unique, and I've only seen this one time in 30 years, where the partner didn't have the liabilities, they are able to avail themselves of an ordinary loss deduction in that case. But you have to have an overt act of abandonment. In the context of a worthless interest deduction, the key thing there is that you have to be able to show that there's no liquidation value and no potential value in that partnership interest that you're claiming to be worthless. I mean, you still be a partner in the partnership, you're still going to have a share of the liabilities, but again, you still have to show and demonstrate that there's no value in that partnership interest. So that's it in a nutshell. With that, I will turn it over to Jody. Let's see if I can do this now. Okay. All right. So take it away, Jody.
All right. Thanks, Rick. Again, I'm Jody Biedenball. I'm a partner in the Columbia office of Nelson Mullins. My practice is banking, bankruptcy, and creditor rights. I'm going to give you a very quick overview of bankruptcy and commercial leases. Most of what I will be talking about is what the bankruptcy code says as to how commercial leases are treated, and then my partner Sean Faulkner will give you a little bit more examples and practical insight as to how that actually plays out both in and outside of bankruptcy. First, a poll question: when do you think commercial bankruptcy filings will peak? A, first quarter of next year, B, second quarter of next year, or C, they have already peaked. We are getting a lot of support for second quarter of 2021. So it looks like we're going to have 72% voting for the second quarter, about 20% voting for the first quarter. I have no idea what the answer is. I was just curious as to what the group thought, when we will see the bankruptcy filings hit the peak. This slide, overview of discussion, I'm going to have a brief talk on what the current bankruptcy landscape is, then a very quick bankruptcy overview, and then I'm going to talk about the treatment of commercial leases in bankruptcy. In terms of the current bankruptcy landscape, we get asked a lot, has there been an increase or a decrease in the number of bankruptcy cases? The answer to that is both. Consumer cases are down, and commercial cases, as you would expect, are significantly up compared to prior years. The industries that have been most impacted, no surprise here, consumer-facing industries have been most challenged. Retail, chain restaurants, and gyms. You're also starting to see a significant amount of distress in the energy sector, with mining, oil, and gas companies starting to file in an increased amount. What size of companies have been filing? All sizes, of course, but it is noteworthy, I think, that large companies have increasingly filed Chapter 11 cases in recent months. There have been a significant amount of cases by companies with over $100 million in liabilities, and then mega cases, which are companies with liabilities in excess of $1 billion, far exceeds what we saw last year, and is the highest amount thus far already for any year since 2009. Why hasn't there been a more significant landslide of commercial filings? There are a number of reasons for that. Governmental relief is one, local foreclosure and eviction moratoriums is another reason, and patient lenders. The lenders have agreed in a lot of matters to extend or forbear, and the availability of low interest rate liquidity has also contributed to it. Do we expect more filings? Absolutely. When? This is the poll question. I've read a lot of secondary articles and heard from speakers who predict the first quarter of 2021. I don't know if that's going to be the case or if it'll be the second quarter, but I do believe it'll be one of the two. I don't think we're at the peak right now. All right, so next slide is, has there been any recent modifications of the Bankruptcy Code? Really the only recent substantive modification was Subchapter 5 has been enacted, which allows small businesses to reorganize in a much more streamlined manner. It's much less expensive. There's some give and take under those provisions, but it really is supposed to be a quicker, less expensive version of Chapter 11. Under the CARES Act, which was the legislation passed as a result of the pandemic, the dollar amount threshold of what the amount of debt you need in order to qualify for those small business protections was increased from 2.7 to $7.5 million for cases prior to March 27, 2021. All right, short bankruptcy overview. First slide is what are the chapters under the Bankruptcy Code. I'm going through this fairly quickly just to sort of set the table as to some of the terms I'll use as we talk about commercial leases and bankruptcy. The two chapters that will come up in a commercial bankruptcy case are Chapter 7 and Chapter 11. Those are the chapters that are commonly filed by businesses. In a Chapter 7 case, that's called a straight liquidation. A bankruptcy trustee is appointed. That trustee will liquidate the debtor's assets, and those cases last usually about 9 months or less. They certainly lasted much longer than that, but I think 9 months is a good average. Few Chapter 7 cases have assets to actually liquidate. In a Chapter 11 case, that is the reorganization chapter, the ultimate goal is to confirm a plan of reorganization which will provide a discharge or relief from debt. It is increasingly more typical, however, for a Chapter 11 to be filed and the debtor to actually liquidate themselves either by motion or a liquidating plan in the context of a Chapter 11. The real benefit of doing it that way is the Chapter 11 debtor in most cases will remain in possession and in control of their assets in most circumstances. Upon filing, there is an automatic stay. The automatic stay is essentially a federal injunction that bars all activity to collect on a debt or recover the debtor's property. It is very broad and it is punishable by sanctions, including punitive damages if you violate it. There are exceptions in the Bankruptcy Code to the automatic stay. One of those exceptions is that creditors can get relief from the stay for cause or if there is no equity in the creditor's collateral and that collateral is not necessary to an effective reorganization. One slide on claims classification and treatment in bankruptcy. Generally, in bankruptcy, claims are classified as secured, unsecured, and priority. The priority claims are assigned different levels of payment in the Bankruptcy Code. A claim that is unsecured and is not priority is called a general unsecured claim. Those claims get paid last after the secured creditors are paid from the value of their interest in their collateral. If a secured creditor is undersecured, then it'll get paid the value of its collateral and it will have a deficiency claim, which is a general unsecured claim. In order to assert a claim in bankruptcy, you file a proof of claim by the deadline set by the bankruptcy court. There's an official form for submitting a proof of claim, and typically you would attach the underlying documents to the proof of claim, such as your invoices or your account summary. Recovery varies widely from 0 to 100%. Chapter 7 cases, recoveries are more typically very small or nothing. In a Chapter 11 case, you may have the opportunity to get a bigger recovery, but even in a Chapter 11 case, a general unsecured claim in a Chapter 11 case often takes a pretty big haircut. Briefly, executory contracts and unexpired leases. In the Bankruptcy Code, there's a section 365, which gives the debtor the ability to assume an executory contract or an unexpired lease or reject an executory contract and an unexpired lease. If they assume it, that means the debtor wants to stay in the contract. If they reject it, that allows the debtor to get out of that contract. Under that same section 365, the debtor is given very wide authority to assign assumed executory contracts and unexpired leases to third parties in connection with a sale of those assets. In order to assume an agreement, the debtor must cure all defaults and provide adequate assurance of future performance. That cure requirement means that your balance due gets paid. That's your opportunity if you're the landlord and your lease is getting assumed. That's your opportunity to get paid. Because of that, debtors will often try to negotiate that amount down as a precondition to assuming the contract. In a Chapter 11 case, the debtor has until confirmation of the plan to make the decision on whether to assume or reject. Commercial leases in bankruptcy, prior to that assumption and rejection decision, if the landlord is able to have the lease terminated before bankruptcy and that termination is final, then the law is clear that that lease is not property of the bankruptcy estate. Often the debtor will file before that lease termination is final to preserve its rights. The automatic stay bars collection of the pre-petition rent and enforcement of post-petition defaults. The debtor must timely perform its post-petition lease obligations. It should pay its post-petition rent and other charges. Issues do come up in cases as to when the obligation arises. Does it arise pre-petition or post-petition? And there are a couple of rules for deciding that. The time period for assumption or rejection for non-residential leases under which the debtor is the lessee, the Bankruptcy Code has put a time clock on when the debtor can make that decision. It has an initial time period of 120 days after they file bankruptcy. The court may extend that for another 90 days, so you get a total of 210 days. Those motions for the 90-day extension are very often granted. But the code now says that after that 210-day period, any further extensions require the landlord's consent. So that shifts the balance of power a little bit to the landlord and gives the landlord a little bit more control over what's happening. Once the debtor makes the decision, they're going to move to assume the lease or move to reject the lease. Bankruptcy courts apply a business judgment standard for that decision. It is a very deferential standard for the judgment for the debtor. Rarely are you going to, as the creditor, the counterparty to the lease or the counterparty to the executory contract, rarely are you going to win that battle. Assumption of a commercial lease is subject to the cure and adequate assurance of performance requirement. The Bankruptcy Code does provide a little bit of an exception in that the debtor is not required to cure non-monetary defaults, which are incapable of being retroactively cured. An example of that is a continuous operation provision. With respect to shopping center leases, adequate assurance is generally subject to the provisions in the lease relating to radius, location, use, tenants mix, and exclusivity provisions. With respect to rejection, that generally results in the termination of the lease. The landlord, as a result of the rejection, gets a lease rejection claim, which is a claim for breach of the lease as of the bankruptcy petition date. There is a statutory cap on the amount of that rejection claim. So that concludes my portion of the presentation. I will turn it over to Sean Faulkner. Sean, I will keep the presentation on my screen. Just say next slide when you're ready to move forward.
Okay, sounds good. I appreciate you doing that. Hello, everyone. My name is Sean Faulkner. I'm a partner in the Greenville office of Nelson Mullins. My practice primarily focuses in landlord, shopping center developments, leasing, acquisition, sales. Also represent lenders in the same type of transactions and that sort of thing. And occasionally, and more often than not, I'm also involved in bankruptcy filing from the landlord standpoint because of that representation. So we're going to go through some scenarios and lease strategies that we run into both pre and during bankruptcy involving commercial leases, commercial tenants, and commercial landlords. So Jody, if you'll go to the next slide, we have a polling question here. Need everyone to try to answer it. What advantages does bankruptcy give a tenant? We have 4 options there. I'm going to click open the polling. Looks like a majority are looking at it from the standpoint that I tend to look at this. Let's see. Got about 70% voting. Remember to click your submit button when you answer the question. We've got about 80%. There's some folks out there that haven't responded to the polling question yet. All right. All right, great. Yeah, looks like most of the people clicked all of the above. The advantages bankruptcy gives the tenant, gives them an opportunity to downsize brick and mortar operations, and it also allows tenants to reject or assign the lease with little say by the landlord. Next slide, Jody. So the COVID-19 pandemic has prompted both commercial landlords and tenants to reevaluate and take a look at their leases to understand what their rights and obligations are in face of a pandemic like this that we haven't really seen in our lifetime. If you haven't, or your clients haven't taken the opportunity to pull out their leases, which is the means of making the income from these properties, they should do so and look at those in light of the recent events with the COVID-19 pandemic and the lockdowns especially. There is a possibility, and it's already occurring in some states where the lockdowns are being reinstated. Those lockdowns prompted a lot of tenants to go to their landlords to ask for deferment of rental payments and that sort of thing, and that could actually be coming back around here early part of next year, depending on how the pandemic plays out, how the vaccines are distributed, how many people take the vaccines, and all that sort of thing. So you need to be familiar with your leases, and you need to specifically look at your force majeure clauses, because a lot of people believe that force majeure clauses in the leases excuse rental payment if you're on the tenant side, and the landlords are concerned at the same time that they may excuse rental payments as well. 9 times out of 10, those force majeure provisions do not exclude the payment of rent. Most of them will specifically say that, but even if they don't say that, those provisions under the law of most states are strictly construed. And so it is very difficult to argue that you don't have to pay rent under those, but there is the exception. So the point of all this is take a look at your leases and be prepared to discuss your lease provisions with your tenants in light of the COVID pandemic that's going on right now. A lot of tenants are, even if they haven't filed for bankruptcy, or in the process of planning for bankruptcy. And the reason they plan for the bankruptcy is it does give them a means by which they can downsize their operations. It also shifts the leverage under the lease from that of the landlord to the tenant because of the favorable treatment that the bankruptcy code gives to leases, as Jody went over. The bankruptcy code, in a lot of instances, in addition to those items that Jody discussed, allows the tenant to ignore the assignment provisions of the lease that restrict the ability to assign the lease. It may, in some instances, allow the tenants to circumvent other provisions of the lease that have to do with use restrictions and that sort of thing. So it's a case-by-case basis that it has to be evaluated, but it is a powerful tool for the tenant. So, and as Jody indicated, the reason it's such a powerful tool is because the lease can be rejected, assumed and assigned to a third party. So the landlords have to be aware of that when they first have discussions with the tenant, whether it be pre-bankruptcy or post-bankruptcy. And it's a little bit different environment these days than, even 5 years ago for the landlords dealing with tenants that are looking at filing bankruptcy or have already filed bankruptcy. And it has to do with the fact that we have, the e-commerce that has emerged and the difficulty that landlords are running into with finding tenants that actually need a significant amount of space when they're looking to relet their premises. So it's something that if you are associated with landlords or lenders that lend on these type of properties, they need to be familiar with the provisions of the bankruptcy code that Jody went over earlier, and with the leases that secure or provide the income to pay those debts for those properties. Jody, if you can flip over to the next slide. So what do, when a tenant is planning to file for bankruptcy, and we know a lot of them are right now, the first thing they typically do is they will look at their leases or lease, whether they're a single tenant or they're a business that has multiple leases and multiple locations, and they'll identify which one of those are currently profitable, meaning, even with the lease rent payments and that sort of thing, with the sales that are being generated from the space, those are profitable stores. And then they'll look and identify those that are unprofitable. And when they're looking at those that are unprofitable, they're going to really have probably at least two categories: those that are unprofitable and there's probably no way the lease can be restructured, or the store or space can be renovated or modified in order to make it a profitable location, or there's the category of those that can be made profitable with certain concessions from the landlord. And so tenants are going to go through that process, and they should do it before they file the bankruptcy, so that they know which stores they need to target and which landlords they need to target with regards to trying to negotiate amendments or rent concessions or other items that we'll go over shortly, to try to make that lease more profitable. Other factors that go into the tenant strategy when they're looking at which leases they may assume and which leases they may reject, and which leases they need to seek modifications on, is they'll look at the landlords themselves. A lot of times, if it's a larger retail tenant, for example, they'll have relationships with a developer or a REIT or a lender group that extends over multiple locations, and that can play a factor in their decision making with regards to which leases they intend to assume or reject or seek modifications on in a bankruptcy. The other thing that you'll run into, or your clients will run into, when you get into a bankruptcy situation, and this can be pre-bankruptcy or post-bankruptcy, but there are management companies, real estate management companies out there that have become kind of experts in negotiating lease modifications pre and post bankruptcy. And these large retailers especially will go out and hire these third-party companies to negotiate these leases, and they give them the results of their evaluation of the leases and tell them which leases need modified and what concessions they need in order to submit that lease for assumption in the bankruptcy. And it is both a cost benefit strategy, and it also allows the tenant through a third-party agent to have discussions with the landlord and have an individual there that they're dealing with face to face that's not necessarily the tenant, and it acts as a buffer for the tenant with regards to certain concessions and other strategies that are used in trying to negotiate these lease modifications. So I don't know if Jody, if you're seeing it as much as I am, but I am seeing that in most of the larger bankruptcy situations with multiple locations involved, that there's actually a third-party company that's negotiating these lease modifications for the leases that they're trying to assume.
Absolutely, and they are very good at it.
Yeah, very good at it. Next slide. Before we get into the concessions that are sought, from a landlord standpoint, again, there are strategies that should be employed in this current economic environment with the pandemic out there. And that is, again, I can't stress enough, is understanding your lease documents. And when I say the lease documents, I mean the lease, the amendment, and if you've got a guarantee or a letter of credit that secures that lease, you need to be familiar with those as well, because all of those are affected when you start looking at modifying the lease when a tenant comes to you and starts seeking modifications. The other lease related documents you need to be familiar with are your lender's documents and the assignment of leases and rents that are typically executed as part of these loan transactions. And you also need to look at your financial covenants in the loan agreements to determine if these concessions, especially when you're talking about monetary concessions, are going to affect those financial covenants in the lease documents. So we on my end, when I have dealt with these situations with landlords, we not only look at the lease, we look at the loan documents, we understand those. We actually reach out to the lender when the tenant files bankruptcy and let them know immediately what is going on and what are, and we reach out to the tenant if the tenant hasn't already reached out to us to find out what their intent is with regards to the lease. A lot of times you can tell what a tenant intends to do if they continue to pay rent and they stay in the space post bankruptcy. 9 times out of 10, they're either planning to try to assume that lease and assign it or reorganize and assume the lease, but they still may seek modifications. If you see your tenant go dark and the next day they file bankruptcy, lease modifications off the table at that point. So anyway, the point of all that is from a landlord standpoint is keep your lender involved in the negotiations and what's going on. Typically, they will not get directly involved, but they do want to be kept appraised of what's going on, and they do want to have ultimate say in the decisions on the final modifications that are made to the lease in order to allow the tenant to stay in the space. With regards to the type of concessions that are often sought, the most prevalent is, of course, a reduced rental rate. Sometimes that is they ask for a reduced rental rate for the remainder of the term of the lease, or they'll ask for it for a certain period of time and try to make up the rental payments down the road. I typically see this more with grocery store tenants than other retail tenants, and it's because there tends to be a strategy with grocery store tenants that when they file bankruptcy, they want to try to emerge from bankruptcy reorganized, and then they tend to have those more streamlined leases available to sell to other grocery store chains and that sort of thing. So they kind of pass the buck down the road in order to try to get the lease the way they want it or need it to get out of the bankruptcy with their existing debtors. Gross rent comes into play when you're talking about rent concessions. Sometimes they'll come to you and say, we want to take this triple net lease, which is a triple net lease means the tenant pays a base rent, and then they pay in addition to that their share of the real estate taxes and their share of the common area maintenance charges and their share of the insurance on the shopping center. They pay all that separately on a pro rata basis. Sometimes they'll come back and they'll try to streamline and want to do a gross rent lease where they do away with all those charges that can vary from year to year and try to make it a reduced fixed rate that they can budget and manage a lot better across the board. So you'll see that a good bit of time. Percentage rent comes into play in some retail leases, and tenants will tend to come to the landlord and ask to change the breaking point for determining when percentage rent is paid, or do away with it altogether. I have seen recently, especially with the emergence of e-commerce, a lot of larger tenants that occupy larger spaces actually coming to the landlord and wanting to reduce the footprint of the space that's being leased and of course that in turn reduces the rental rate by the square footage that the space is reduced. Early termination, you'll see tenants come and say, we want to, go ahead and we want to preserve this lease, but we do not want it to run for the next 20 years, depending on when the bankruptcy files. We would rather it be a 10-year lease. That fits their, for whatever reason, it fits their business model. So you will see them seek early lease terminations at some point. And I see them ask for lease extensions as a incentive to agree to other rent concessions or other concessions in the lease. And they'll come to you and say, we've got 4 years left on this lease. If you'll agree to reduce the rental rate for the remainder of the term, we'll agree to go ahead and extend the lease out another 6 years to make it a 10-year lease, but at this lower rental rate. And sometimes that works out, especially in older shopping centers and stuff where the debt payments have been paid down and that sort of thing. I rarely see them actually seek any sort of sublease as part of a pre or during bankruptcy strategy, but tenants will often ask that the sublease provisions in the lease themselves actually be modified to allow them to more freely sublease the space if they emerge from the bankruptcy. And then very rarely, and this is mostly pre-bankruptcy, we'll have tenants that'll come forward and they'll offer a cash buyout of the lease. And that's typically when you're at near the end of the lease term, you got 2 or 3 years left. It doesn't make sense for the tenant to stay in the space. They've evaluated everything and they want to move on. They'll come up and kind of offer the cash lump sum payment that would typically be paid in the bankruptcy proceeding itself if the lease is rejected. They'll offer something similar to that to try to go ahead and just have the lease terminated before they get into bankruptcy so they don't have to deal with it. Considerations when the landlord is approached by a tenant for these type of concessions. Again, the landlord should be familiar with the lease. They should look to see if as part of those concessions that they have the tenant agree to delete any kind of exclusive use provisions in the lease. A lot of times tenants have lease provisions that say the landlord will not lease other space in the center to competitive businesses. A lot of times those exclusive provisions are overreaching and the landlord can get the tenant to agree to modify those, to pull those back as part of the rent concessions. you also need to, as a landlord, consider when you're being asked to look at these concessions, you get to be familiar with the other leases in your shopping center to make sure that if you agree to a modification, especially to a reduction in the square footage or to a closure of a store voluntarily, that you don't have provisions in leases with other tenants that are tied to that anchor tenant in most instances. In other words, there are some shop tenants in shopping centers that have negotiated provisions in their leases that say if the bigger anchor tenant closes its doors or reduces its square footage or something like that, that they in turn get to reduce the rental rate under their leases because they're relying on that anchor tenant to bring in the customers that they're feeding off of for their business. So you need to be aware of that when you're looking at these modifications and lease concessions that are being requested. And again, make sure you understand and keep your lender in the loop when you're considering these concessions. If the lease that is in bankruptcy has a guarantor, and that does occur, you need to make sure that the guarantor joins in any kind of rent concessions that are granted and agrees to those and acknowledges that those do not affect its obligation as a guarantor of the lease. They're third parties to that, and if you do not have them join in those lease amendments that put in place any kind of concessions or modifications to the lease, they can argue that they're not obligated to guarantee the lease because of those changes. They were material, and they didn't agree to them. And finally, before you consider any kind of lease concessions, the tenant should provide you with their financial information, especially the financials associated with the space itself. And you need to get those and look at those and evaluate those independently of what the tenant's telling you, to make sure that what the strategy that both the tenant and the landlord are looking at and trying to preserve the lease is based on actual numbers. Just don't take the tenant's word for it. They should be willing to provide you with those financials, even if the lease itself doesn't call for those, and you should request them. Other things that I don't have listed here that landlords might want to consider is if the lease itself is not guaranteed and the tenant's asking for concessions, maybe you ask for a guarantor to be added to the lease, especially if they're trying to preserve the lease for the remainder of the term. You may want to seriously consider adding provisions to the lease to address future government mandated closures and how the rent's going to be handled at that point, rather than relying on the parties getting together to do deferment of rent. I see a lot of tenants now these days actually negotiating into leases up front or as part of lease modifications, and landlords, by the way, as well, alternative rent provisions in leases. And basically what those alternative rent provisions look like is it says, if a government mandate is put out there that forces us to close or limit the business in the space, and that business has a financial impact on the business, and we can prove to you, landlord, that it does by providing you financials, then we can reduce our rent by 50% so long as we're able to be open for that period of time. And then in the event of a closure, we can do it for a limited period of time. But then we need to make a decision if it's more than 60 days or 90 days, whether the tenant continues to stay in the lease, terminates the lease, or resumes paying the full rent. Those provisions can take all different kind of shapes and forms depending on the type of space and business you're dealing with. But you should consider alternative rent provisions that address specifically COVID closures, as opposed to trying to rely on force majeure or the good faith of the parties to agree to deferment of rent in those situations. Richard, how much time do I have left?
Actually, we're just a little over.
Okay. I can keep going on this. We can flip through the lease amendments really quick, and then I'll move on. The amendments, when you actually get an amendment in your hand, there are certain provisions that you need to be aware of when you're looking at those. Typically, you will want, if the tenant is in bankruptcy, the effective date to reflect that the agreements in the modification are not effective unless the lease is assumed by the tenant in the bankruptcy. In other words, you don't want all these to be, you want to make it clear that you're only agreeing to these concessions so long as the lease is assumed. Oftentimes these days in bankruptcy, the rent has been deferred for the last, from March through June or something like that. The tenants will want you to waive that. You need to specifically address that in the lease amendment, whether the deferred rent, any rent that was deferred previously is being waived, or if they're required to pay it back. You're going to want estoppels and waivers in the amendment with regards to existing defaults and those sorts of things under the lease. And you're going to, again, want to make clear that the amendment only comes into play if the lease is assumed in the bankruptcy, and the tenant on the opposite side of that is going to want to make clear that the lease amendment doesn't obligate them to assume the lease in the bankruptcy. And then again, consider adding that alternative base rent provision to the modifications or amendments before you finalize them with the tenant, so you don't have any questions moving forward as to how rents are going to be handled if there is a COVID closure. And with that, I think I've finished with my presentation.
All right. Well, again, we're a couple minutes over. So first, want to thank everybody for being with us today, and I also want to thank Jody and Sean for their presentations and informative advice dealing with bankruptcies and lease negotiations. And I want to remind everybody about our event tomorrow, which is year-end planning for our real estate companies. So that is the fourth of our series at 8:30 tomorrow. So please join us then. And again, thank you for joining us today. We appreciate it. Take care.